On Sunday, the federal judge overseeing the case surrounding Trump's efforts to overturn the 2020 election, Judge Tanya Chutkin, she reinstated a gag order on Mr. Trump. Judge Chutkin first issued a limited gag order exactly 2 weeks ago today on October 16th. But she paused the gag order at the request of Trump's lawyers, who are in the process of appealing it. And then there was a 9-day pause in which the special counsel's team later argued that Trump wasted no time in attacking federal prosecutors and potential key witnesses, including his former chief of staff, Mark Meadows. With yesterday's ruling, the former president is now barred again from making any remarks targeting witnesses, prosecutors, or court staff. To be clear, this gag order is separate and apart from the one imposed in his New York civil fraud case, in which Trump has been fined $15,000 for violating it not once, but twice. Maybe it's a pattern. Because after Judge Chutkin imposed the gag order today, Trump again went on the attack, going after former Attorney General Bill Barr, a potential key witness in this case. He called the judge a, quote, Trump hater, and he threatened President Biden with payback, almost all of which might be a violation of said gag order. With gag orders like this, who needs gag orders? Joining me now is Joyce Vance, former district attorney for the Northern District of Alabama. Joyce, thank you for being here. Please help me understand whether we are barreling towards a stress test of bail conditions. Are judges going to have to take up in earnest the question of whether they need to jail a former president ahead of a trial?
So I think as reluctant as the judges will be to do anything that would look like interference in the election, ultimately Donald Trump seems intent on pushing these buttons. He's had a lot of opportunity to walk it back. Instead, he continues to advance his conduct. For instance, Alex, just leaving up some of these earlier posts, the post about Mark Meadows, which the last time I looked at Truth Social was still up and had not been taken down. That would be a violation of the gag order at this point. So Trump is not going to make life easy for any of the judges here.
Today, the DOJ announced that they were indicting an Alabama man for transmitting interstate threats. He had left threatening phone messages for DA Fani Willis. Do you think the DOJ is trying to convey its seriousness in terms of threatening behavior in and around this case? And is that a subtle message to Donald Trump?
I don't think that there's anything subtle about it. DOJ has always taken an aggressive stance about protecting witness safety in every case. This is the sort of issue, and I can tell you on the handful of cases that I was involved in where there were threats to witnesses, people in a U.S. attorney's office drop everything. They put their heads together. They figure out how to protect the witness, whether they need to go back into court. These matters are taken very seriously. And so the U.S. attorney in Atlanta took a look at this threat, went ahead and indicted the case very quickly, will pursue it very vigorously. Donald Trump needs to understand that there is a line that you cannot cross over here and that he has become perilously close to it.
The other Trumps will be talking in court next week, this week. On Wednesday, Donald Trump Jr. will be testifying in the New York civil case brought by AG Letitia James. On Thursday, Eric Trump testifies. Next Monday, Donald Trump himself. And next Wednesday, Ivanka Trump, who was originally scheduled for this Friday. Joyce, what is your expectation with these Trumps? Are they going to be pleading the fifth, as they have in previous depositions? Or could they actually testify with some material information that would be useful to the AG?
So they'll have an interesting decision point here because they're being called by Letitia James as part of her case in chief, the case the government is putting on to justify the award of damages, in essence, that it's seeking from Trump and the Trump organization. If they're not forthcoming in their testimony, you know, when you have a witness on direct, you have to ask them who, what, when, where, why kinds of questions. You can't lead them to the answer that you want. But if the witnesses aren't forthcoming, then James can ask for permission to treat them as hostile witnesses. She will almost certainly have to do that here. And she can ask them more pointed questions, that really divulge the information she's interested in. Isn't it true that you were present when this conversation occurred? That sort of a thing. And so very quickly, these witnesses get to the point where they'll have to decide whether they'll be forthcoming and tell the truth, whether they will try to dissemble and plead a failure of memory, or whether they will go ahead and assert the Fifth Amendment, which of course is dangerous in a civil case because it means in this case, Justice Engoron will be able to draw adverse inferences from asserting the Fifth, and it could even become a consideration down the road if any additional action is necessary in the criminal justice system as a result of the civil case.
Yeah, and given Judge Engoron's position thus far as vis-a-vis Trump, he is likely to draw adverse inferences from the Trump children should they plead the Fifth. I got to ask you, Joyce, because this case is sort of making its way through the courts. It is the first hearing, today was the first hearing in a lawsuit filed by 6 Colorado voters who, with help from outside groups, including Citizens for Responsibility and Ethics in Washington, are seeking to prevent Trump from getting on the ballot using the 14th Amendment, Section 3 of the 14th Amendment. Minnesota, I think, is going to be hearing a similar case. We've sort of danced around this topic and touched on it a little bit in previous months, but I wonder what you make of it as a viable lawsuit that could work its way up to potentially the highest court in the land, or not.
And it does seem it's headed that way. For one thing, if there are different decisions in Colorado and in Minnesota, you could end up with a split that would make this sort of an attractive issue on appeal. It will be something that the court will consider seriously in any event because of its importance. And this is an issue that I think people can be reasonably conflicted about, because the 14th Amendment, Section 3, says what it says. It says that if someone who's taken an oath of loyalty to the United States participates in an insurrection, then they're ineligible to hold future office. Period. End of story. And for the strict constructionists among us, that would typically be conservatives in this country, the language is relatively clear. There are some legal issues about whether or not the president of the United States qualifies. There's some technical legal language about an officer of the United States. But setting that aside, even if there is a good faith belief that this statute applies and should keep Trump off of the ballot, then there are the political consequences of that legal decision and whether this isn't a decision that's better off left to voters, whether removing Trump without permitting the voters to speak might do more damage than it would do constitutionally.